The divorce process in the state of Maryland seems simple at the outset, but there are a lot of little parts that you can't miss. Otherwise, the case will sit at a standstill. So the beginning of the case involves filing a complaint with the circuit court where you reside. That'll make you the plaintiff. As long as the plaintiff has been living in that county or the state of Maryland for at least 6 months, the court has jurisdiction to hear your divorce. What happens after the complaint is filed, though? The court is going to mail you a summons. And the summons is going to have to be served on the defendant, meaning the person you're trying to divorce, along with a copy of the complaint. Now, you can't do the service, though. So what ends up happening is you have to hire a private process server or just even give the paperwork to a friend or family member or anyone over the age of 18 who's not a party to the action, and they can serve that defendant for you. Now, if the defendant lives in the state of Maryland, they will have 30 days to answer the complaint. If they live out of the state, but within the United States, they'll have 60 days. If they live out of the United States, though, they'll have 90 days to answer. In the event no answer is filed, what will end up happening is that the court will consider a motion for default judgment. And a motion will need to be filed after that time period to answer expires. And if the motion is granted, the court will set the case in for a default divorce hearing without that party being present. Now, if the party does answer and the case is uncontested, the court will naturally set in an uncontested divorce hearing. But if the case is contested, you're going to end up having possibly mediation, a settlement conference, a scheduling conference, and a contested divorce trial. And once in a while, there will be a pendente lite action in the middle of all that. And what's that? It's kind of like a temporary order to get you through to the absolute divorce. And so the divorce can kind of play out in a variety of different ways, but you need to kind of have a game plan in place that is going to take you from point A to point B. And that's going to involve knowing whether or not you're authorized to even file the motion in the first place, and whether or not the court will have power to hear your case. There are deadlines and timelines for being able to file for a divorce. So keep in mind, if you haven't been separated for at least 1 year, you're definitely going to need to seek counsel to determine whether or not you can file without waiting.